Dear participants to this lunch webinar, a very warm welcome. As president of the European Law Institute, it is a great pleasure and my privilege to welcome you all to this webinar dedicated to the ELI response to the European Commission's public consultation on digital fairness fitness check on EU consumer law. Obviously, this webinar is organized as a bid to engage in a dialogue with key policymakers, legislators, industry representatives, and other stakeholders on ensuring that EU consumer law is fit for digital age. In its 2020 document, the European Commission announced its new consumer agenda, in which it committed to analyze whether additional legislation or other action is needed in the medium term to ensure equal fairness online and offline. This is why the EU Commission launched in spring 2022 a fitness check, and on 28 November 2022, a public consultation to determine whether existing EU consumer law is adequate for ensuring a high level of consumer protection in the digital environment. On the 20th of February 2023, the ELI Council has approved the ELI's response to this public consultation, a response prepared intensely by three reporters, Professor Marie-Jules Sørensen, Professor Karin Zein, and Professor Peter Roth, with the feedbacks of a number of advisors as well as of the ELI Council. ELI's response has underlined a number of issues that will now be presented by our three reporters and then discussed also by our wonderful panelists. But before handing them the floor, let me remind you that the chat function has been disabled, but you can bring to our attention all your questions through the Q&A function. Please do not wait until the end to pose questions. We will then answer your questions orally at the end. Now let's start with our three reporters to give you an insight of the most important aspects of the ELI's response. Of course, you can find these response on the ELI website, www.europeanlawinstitute.eu. We will have first Marie-Jules Sørensen. She's associate professor at the Department of Law at Aalborg University in Denmark. She's a specialist of consumer law, has participated in Consumer Law Pro, and is a reporter on the e-Justice portal. She has been a member of the team drafting the ELI model rules for online intermediary platforms, and she is also the co-chair of the very new Nordic Hub of the European Law Institute, and is currently co-reporter on the ELI project on automated decision making. We have then Professor Peter Roth. He's professor of civil law, commercial law, and information law at the University of Oldenburg in Germany. He's specialized in European private law and in German and European consumer law. Currently, he focuses on the effects of digitalization on private law, on sustainable consumer law, and on the enforcement of consumer law. And then Professor Karin Zein. She's a professor of civil law and the deputy head of the Institute of Private Law in the Faculty of Law of the University of Tartu in Estonia. Her main research interests cover domestic and European contract law, consumer law, private international law, and digital law. During 2018 to 21, she was the PI of a scientific project funded by the Estonian Research Council, concentrating on consumer contract law in the digital single market. She has provided expertise for the Estonian Ministry of Justice and for the EU Council during the Estonian EU presidency. Three reporters with main competencies in the field addressed by the EU consultation, and therefore I'm thrilled to give them the floor. And I suppose that Marie-Jules Sørensen will begin. You have the floor.
Thank you very much. And thank you for arranging this event. I will try to see if I can share my screen. Please let me know if this is not Is it visible? Yes, perfect. Well, we have selected some topics and we only have 15 minutes, so we cannot cover it all, but we have selected some of them and I'll go first. And the first one here, let's see if I can also make it happen here. Yes, I can. Okay, so the Commission asked whether there should be additional benchmarks or factors in regards to the average consumer and the vulnerable consumer. And we believe that the average consumer concept is a good concept, but we also believe that there could be maybe some factors being more clear and maybe taking into account behavioral science, the findings of behavioral science. The standard of vulnerable consumer is a little more controversial, we believe. And we refer in the comments, we refer to studies that show that vulnerability is more context specific rather than connected to groups. So it's related to the power imbalances that we experience when we go online and in apps and so on. So based on these people's work on the concept, we raised the question whether we are indeed all vulnerable in the digital environment when we go online, when we go to apps and so on, because of this non-transparent power imbalance. We suggest that rather than, or at least supplementing, trying to add factors filling out the concepts of vulnerable consumers specifically, the lawmakers maybe should consider prohibitions that are aimed at practices that potentially exploit vulnerability. In this way, different potential vulnerabilities can be targeted across groups of age, for example. So this could be done maybe through the blacklist. That's at least one of our proposals. Then the Commission also proposes some information duties. And this is a reminder of automatic renewal and a reminder of inactivity. Those are the ones that I have chosen to address. In the proposal, we challenge the idea of automatic renewal. Maybe the consumer is better off with an ongoing contract, with an ongoing right to terminate within maybe 1 month or so. But if automatic renewal should be allowed, it must be a real renewal of an existing contract. We have to make sure that this is what is happening and not a change of a contract. It's disguised as a renewal. We welcome these reminders because they take into account behavioral science, in this case specifically inertia, where we have a tendency to not change anything if it's already there. And furthermore, these are examples, I believe, of providing the relevant information at the relevant time, also something that has been an issue in regards to the whole information paradigm. We do believe these reminders cannot stand alone, so they need some kind of technical, easy to use steps for the consumers to actually act on these reminders. Lastly, my last point here will be that, one thing of the reminders also I need to say is that if this is too much information, if we believe this is only more information overload and so on, we are actually willing to or open to limiting the reminders to subscriptions where the consumer pays for the subscription with money or other monetary means. We know this is a little controversial, and we are also open to giving the consumer a possibility to expressly opt out of this information. Then my final point. In the response, we discuss various challenges with allowing personal commercial communication in general, and we are particularly concerned about personal pricing. So if you choose to take from the rich and give to the poor, that's fine. But this is a very complex area, and there's a great risk of exploitation because of the profiling that you can do on these consumers. So we suggest that businesses are limited in which information they use to personalize information, and also maybe in general. And the problem here is, of course, to identify which information they are not allowed to use. The purpose of such a limit is, of course, try to avoid taking advantage of a consumer's mental state and so on. And with these words, I will give the floor to Peter.
Peter, you're muted, sorry.
Sorry. My bad. Okay, again, I'll mainly focus on question 1 of the questionnaire, which is about a potential need for stronger protection in the digital market. And without mentioning the name, in my opinion, it's about dark patterns, really. Dark patterns have made it into the law in the meantime. There's a new prohibition in the Digital Services Act, Article 25, paragraph 1, but that only applies to platforms. Otherwise, so for other traders, dark patterns may, of course, come under the UCPD, but there is no special rule yet. They may be unfair, they may be aggressive practices, to be determined in case law. One major problem with the new kind of regime is that platforms' dark patterns may also come under the UCPD, as platform operators are traders as well. Now, there's a strange interaction between the Digital Services Act and the UCPD, as the Digital Services Act has decided not to apply to practices that are covered by the UCPD. But then nobody knows what is covered by the UCPD, so nobody knows what is excluded from the Digital Services Act, which affects the effectiveness of the new rule in the Digital Services Act, because it's highly risky for, say, a public authority to try and enforce a prohibition of dark patterns, only to be told, perhaps in the last instance in court, that actually this dark pattern is also an unfair commercial practice under the UCPD, and therefore the DSA doesn't apply in the first place, and they will lose the case. So one element that affects or that makes the whole thing uncertain is that it's slightly unclear whether the Digital Services Act and the UCPD actually use the same consumer image. As you all know, and Maria has already mentioned it, the UCPD still starts with the average consumer, which is supposed to be attentive, observant, not easy to cheat. Whereas dark patterns implicitly are based on the idea that we are quite easily manipulated by web designs, etc. And we can already see that in discussions about individual web designs, where some people would argue that, well, an attentive consumer would notice me, for example, because I always read the cookie banners before I click anything, but a less attentive consumer will be easily manipulated. So to wrap this up, we think that this sort of need to be fixed, and I'm happy to see that the IMCO committee of the European Parliament has already picked this up and has made a proposal of introducing a prohibition of dark patterns in the UCPD as well, which would then make the one in the DSA obsolete. With a slight problem that I think it's ill placed in the proposal, because they want to put it into Article 6 on misleading action, whereas dark patterns do not need to be misleading. They could also be aggressive, though, so they should basically come into Article 5 into the general clause. Next one. And then two brief additional remarks. The questionnaire, unsurprisingly, very much focuses on information again. And not all problems in the digital market can be fixed with information only. But there are there's one particular example in the questionnaire, ticket reselling, where information is really insufficient, and where stronger measures are needed, like a need for price caps or limitations of professional reselling, prohibition of anonymous reselling, whether there is a risk that at the end the ticket is useless because it's personalized and you won't get into the event in the first place. So just a reminder that information is not everything in consumer law. And the second one, again, a slightly general remark, is again with a new broad, for example, prohibition of dark patterns, what we will start is case law, because every web design is different, and you can take them all through the court system, and it will take years and years until a set of rules has been emerged that provides more legal certainty. And in that sense, in many areas, standardization would be helpful because it would avoid these harmful delays. Cookie consent, why does everybody need to be allowed to design their own cookie consent banners? Just have one that everybody needs to use, that consumers get used to, where they know where to click, and the problem is solved. Influencers that have to show one when they, or demonstrate when they advertise for someone else's goods. Why do not simply giving them one term that they have to use, like ad for advertisement? Why do we have to run through a trial and error? One good example for that would be a cancellation button, a termination button, with a simple message on it, standardized, easy to understand for everybody. Thank you.
And finally, I will focus on two aspects: the issue of free trials and the consumer's right to have a right to human interlocutor. First, the free or also reduced rate trials is a known problem from the consumer's perspective, because traders are luring consumers into the so-called subscription traps, that the first 3 months are free and then the contract self-executes itself into a paid version, and it is able to charge the consumers because the consumers are asked about their credit card data already when entering into the free trial. And of course, the consumers often forget to cancel the subscription after the free period is over. The Commission has asked about 2 possible solutions. First, whether consumers should give an express consent before they are switching to the paid service. And second, whether traders should be allowed to ask payment data only after the free period is over. And we agree with both solutions. First, the express consent, or I should even specify the separate and express consent requirement, is something that we already know from the European Consumer Law, from the new Digital Content Directive and the Sale of Goods Directive. Such an obligation is already existing also in the US and is discussed also for the UK. There are certain problems that we should still take into account. First, the requirement that traders are permitted to ask payment data only after the end of free period could be easy to circumvent in a way that they ask for reduced payment in the beginning for 1 cent or 10 cents. And we should take that into account. And then we should ask whether we allow opt-in via express and separate consent, because it could be that some consumers really are interested in such conversion in the first place already. That, for example, I know that, okay, the first 3 months I don't pay anything, but then I will pay €8 per month, and that's okay for me. But then again, this should be really a separate and express consent for that. And we also need to make sure that these kind of consents are transparent and so on. And we should also give a thought about the sanctions and penalties if the trader doesn't comply with these prohibition. And should there be a fine? Or in addition, maybe we should also consider the services then to be unsolicited goods or unsolicited services, so that eventually the consumer doesn't have to pay for that, even if the contract was self-executed against the law. Concerning the right to a human interlocutor, again, we agree this would be a good idea, and it would follow the already existing approach in the European law or in the proposals of European legislative acts. True, these acts are mostly about automated decisions, whereas here we are talking about the right to communicate. For example, we all probably have been in the situation at the airport where the flight is cancelled or delayed, and we want to get someone on the phone, and there is only the possibility to interact with a chatbot, and the chatbot knows all the answers except the one that you need. So yes, at the consumer's request, there should be a right to contact a human, not necessarily by phone. It can be also via an online chat, but the human-centered approach that we see already in the GDPR, we see in the DSA, and we see in several proposals, be it the new Consumer Credit Directive or AI Act. I think this is the right way to go. Thank you.
Thank you very much. Thank you very much to all three for the work you have done in preparing this response, and also for this very clear presentation of some fundamental aspects. We will certainly come back to that now with the various intervention and also in the Q&A section. We have now the pleasure to have Kasper Drajewski from the BOIC Association. With a background in research on law and technology, he's in charge of BOIC's work dedicated to digital fairness. And before joining BOIC as his postdoctoral project at the European University Institute in Florence, Kasper coordinated a project for the development of a machine learning powered system for protecting against unfair contract terms and privacy policies through an explainable AI. That's the Claudette and further project. Why a woman? I don't know, but okay, that's a different issue. And we are very happy to have you today. And Kasper, you have the floor.
Thank you very much. Thank you for the invitation, the opportunity to be here and to follow up on that first question. Claudette was short for clause detector. So basically, that's the whole story, really. I will give you. I want to use this opportunity to give a brief run through BOIC's work on digital fairness, which started a few years ago when we started looking at the notions of vulnerability, consumer vulnerability, whether they remain viable in the digital economy, in the data-based economy. The research we started then has led us to the identification of digital asymmetry as this imbalance, which was already mentioned here today, based on knowledge, and this knowledge imbalance cannot be solved by more disclosure, on control over choice environments and power to shape the contractual relationship. Excuse me. And now, to us, the major issues were the way that this disempowerment of consumers and the way it is causing a loss of trust in markets and societies. And in this presentation, I was able already to include some very interesting findings from our forthcoming survey on digital fairness that we have conducted across 8 European member states. This is still the final. This is still the publication is still coming, but the data is very interesting. For instance, we have seen that 55% consumers have lost trust in a company and stopped using its services because they felt manipulated, and this rises to 65% in the 18 to 34 age group. When we discuss trust, we should also talk about trust in the system of protections, and only 22% consumers feel at least somewhat satisfied about how they're being protected. There is also we also obtained quite depressing numbers regarding consumers who did not feel there was any chance to obtain results when they felt violated by a digital practice. Our postulates, our position after these findings were that the UCPD fairness test has to be updated. Digital asymmetry must be recognized as this state of imbalance and needs to affect how we think of unfairness in respect to digital services. We asked for a fairness by design requirement so that traders benefiting from this imbalance of power would be in a position to be placed in to have a duty of care to safeguard choice, to prevent known decision-making biases. And we've seen that 65% consumers have felt manipulated by the design of web pages. And our major ask is a reversal of the burden of proof for traders who are benefiting from digital asymmetry to come forward with the evidence to prove their compliance. And this is to address knowledge asymmetry on the part of consumers, but also on the part of enforcers. Secondly, we asked for the updating of the definition of transactional decision. This is something that was put forward in the revised guidance document to the Unfair Commercial Practices Directive. As we all know, transactional decision is to be understood broadly thanks to case law of the CJEU. Now, under the new guidance, it also covers cases like continuing to use the service, scrolling through a feed, deciding to view advertising content, clicking on links. So shortly put, all the typical decisions that a consumer interacting with digital services in an engagement economy, in an attention economy, has to take. Now, this has pretty far-reaching implications when you think about algorithms which boost engagement, which cause consumers to, for instance, browse social media longer than intended. And our results show that at least half the time, half of respondents to our survey said that they spend more time on social media than they wanted to, at least half the time, and 33% said they regret it. And another very interesting and very current issue that arising there is chatbots using large language models. When you think about consumers which engage with ChatGPT, for instance, and they access the website of OpenAI, and they click on ChatGPT, and they are taken directly to the chatbot. They're not shown any warnings what their engagement with the bot may lead to. If they dig really deep on the website, they might reach research papers which show that what this bot can do when it goes off the rails, so to speak, when it might start incentivizing them to extreme behavior. You all know the examples. And we asked for prohibitions regarding, because as far as there's always value in specific prohibitions. In this case, in particular, we asked for the prohibition of use of psychographic profiles to exercise emotional psychological pressure. And in our results, we've seen that only 16% consumers accept personal data being collected for the reason of targeting based on inferences about life situational vulnerabilities, and for price personalization. Which brings me to the BEUC consultation response paper, in which we try to address all the topics flagged by the European Commission, but to use the opportunity that we were able to respond to the to the consultation to include all our points. Our major postulate remains that to keep sight, not lose sight of the forest for the trees, and to pay very close attention to the high-level issues that we have discussed before. Now, we were able, aside from the reversal of the burden of proof, the duty of care, the fairness by design, we're also looking at, and this is something we are researching now, and there will be more research coming on this in a position later during the year, key concepts of consumer law. What does it mean to be a trader nowadays? We all know that in these massive network environments where you have the platform and a myriad of little companies with, and very often potentially illegal activities are being outsourced from the platform to these companies, and they are not seen as traders under consumer law. They're acting on their own behalf in their own name. The consumer does not see them, but this is where the illegality might happen. Another example, influencer agencies. What the consumer sees is influencers, but the actions of the influencers, the way they operate, their commercial practices are very often being defined by the agencies for which they work, which again are completely invisible to the consumer, and they're not considered traders because they're not present in this consumer-trader relationship. Another term that needs to be looked at, professional diligence. It's part of the paradigm for assessing unfairness of commercial practices under the UCPD, but we have but traditionally professional diligence is based on this notion of a diligent operator. And we have only a handful of high-tech companies out there, and none of them are really compliant. We don't really know in many cases how exactly a diligent operator should behave in specific situations. So that is a major challenge that needs to be looked at, and this is also something we're working on right now. Other include consumer harm. As we know, the UCPD does not require harm to be proved. At the same time, we need to be very mindful of types of consumer harm which are arising under the data economy, also going beyond the traditional framing of protection of their economic interests, as the UCPD puts it. A lot has been said already about the average consumer. The concept keeps receiving flack, and rightly so. We have seen a preliminary question to the CJEU regarding bounded rationality. This is definitely one of those items we are paying very close attention to right now. Preclusionary effects. That's another issue that we brought up, because due to the fact that we've seen a chain of maximum harmonization instruments, all of which purport to regulate their respective areas, and at some time, in some cases, the regulation, the substantive requirements for specific types of technology, for instance, might not be there, which raises a question: does that mean that member states can go a step further and regulate, or not, because of the occupied field doctrine? Example, AI regulation and its substantive focus on high-risk AI systems. There's very little there about systems which are non-high risk. We all know that there's no work being done on updating the proposal on the to account for general purpose AI, but the problem remains: if a maximum harmonization instrument regulates by not regulating, does that mean a member state can go one step further or not? And this is an area of concern for us. And then we have specific prohibitions, which we're still asking for, and we're also asking for a horizontal regime to protect children. This is one of the record numbers we've seen in our survey. 75% consumers believe kids are not sufficiently protected currently from being monitored and influenced by digital services. And I will use my we were a little over time, so I'll be very brief on a very short selection of specific recommendations. We're asking for a right to meaningful personalization. And by that, I mean, I won't bore you with the data right now. You'll see the survey as it comes out. What we mean is that very often the promise behind personalization, of relevance, of improved service, which is often forms the core of the utility value of a service, like take search engines. They function because of relevance, which is based on personalization. At the same time, you have systems like TikTok, which don't even profile you. They're based on open cluster optimization, where you're dynamically assigned to clusters of users which have a similar clicking pattern to yours. There is very little that can be said about semantic control of such systems. It's near impossible, which is a major worry about the application of the DSA right to a recommender system that is to one option mode of operation, which is not based on profiling. And then we have the ban on dark patterns. As was already mentioned today, there has been a proposed an amendment to the UCPD under Article 6. I'm sure this will be discussed in more detail. What BEUC asked for was indeed a horizontal prohibition on dark patterns that would be reinforced by an anti-circumvention clause, and to the extent to which this may be achieved by the amendments proposed under the Empowering Consumers in the Green Transition Initiative, that is something we're analyzing right now. So to close, we have a dedicated project to support and help guide the fitness check process. We will be publishing the survey results very shortly. We have ongoing research into operationalizing digital asymmetry and the reversal of the burden of proof, and this is coming this autumn. And then we have a chain of positions which are in a pipeline. The first two that will be published will be personalized pricing and influencer marketing, and then some. And with this, I leave you. Thank you very much for your attention, and I'm looking forward to the Q&A session.
Thank you very much. Thank you very much also for this insight into the BEUC's work and some of the statistics that we will be able to read with interest when the document will be published. We will continue now with the presentation by e-commerce Europe's position, and that's Mike Janssen. He's in charge of e-regulations at e-commerce group Europe, where she leads the work of the association on a broad range of regulatory topics that are relevant for the digital commerce industry, including consumer rights, product safety, platform-related legislation, and other broader issues, such as the rise of seamless commerce, omni-channel retail. And this is to say that I'm really pleased to give you the floor, Mikey, for your presentation.
Thank you very much. And thank you very much for the invitation as well. We're happy to be here. This is, of course, for us also a very important topic. And I see I've been already in some meetings with several of the panelists. So happy to be here. As e-commerce Europe, we are firmly invested as well in consumer protection and also in the enforcement of existing consumer laws. We believe that businesses online or offline have a long-term interest in building trust by protecting their consumers. And as representatives for the digital commerce sector, we've also closely witnessed quite rapid developments in the retail sector in the last years. We've seen that it has grown from one in which online and offline were operating separately to a highly digitalized sector in which businesses largely adopted some form of an omnichannel approach. And if we then look at the legislation, we believe, maybe a bit in contrast to some of the other panelists here, that the EU already has a very complete and flexible legislative framework. This consists of EU consumer rules, but it's also complemented by other legislation, such as indeed was already mentioned, the Digital Services Act, but also the upcoming Data Act or AI Act. We believe that overall this framework is still fit for purpose. There are principle-based provisions which can address a wide range of practices and are also broad enough to cover, in our view, technological developments. But we fully support the Commission's objective of ensuring a safe and trustworthy digital environment. And we also hear the calls from the other actors to improve the current situation. The question is then, how can this best be achieved? So if, like us, we believe that the rules themselves are fit for purpose, we may want to look further also into how consumer trust and protection can also be strengthened in other ways. And we believe that for any rule to function successfully, all actors involved need to be aware of their rights and their responsibilities also. So this includes consumers, but also businesses. But it must also be enforced effectively. And especially I think that on enforcement, still quite a lot of steps can be taken to improve the current situation. So I think it's also mentioned in the Commission's behavioral study that the effectiveness of the existing framework might also be undermined a bit by the insufficient enforcement in different countries. So we believe the solution at first should not be to change the legislation itself, but to fix the problem with enforcement as well. And there's some suggestions that we have how this could be achieved, for instance, by improving some of the resources and powers, the enforcement authorities. It's also something that we hear currently from some of the authorities in the current discussions on the enforcement package of the European Commission. But also, for instance, the technological skills or the knowledge of these authorities, this is something that really could be amped up. There's also been some good examples of a guidance that has been provided to businesses on what is and what is not allowed. And for instance, by the Dutch Consumer and Market Authority, which has really proven very helpful. So this is something that we also really encourage. And we also see that there's still some room for improvement also within and across countries between the enforcement authorities, for instance, with the consumer authorities and the data protection authorities, because of course, we're not talking about isolated issues here. Maybe then I would like to make a point, and it's already been mentioned, some of the changes that are currently also being proposed on some other files. We see that the Commission is investing a lot in impact assessments, in studies, in consultations, and we're all here today, and we've also all contributed to these exercises. But it's quite hard to explain to our members and to businesses in different countries that while we're all in the process and we're asking them to participate in this, at the same time, the co-legislators are already making some changes in some other files that the original scope may not have been intended to cover these issues. So it can sometimes even go beyond. For instance, if you talk about the withdrawal function in the directive that was originally targeted at financial services, or if you look at empowering consumers in the green transitions, and there we already see amendments on dark patterns in general. So we are a bit concerned that there could be a scenario in which businesses have to start implementing the changes that are coming through all these files, for instance, to the CRD and the UCPD, only to have to start over again when we have the fitness check concluded and potential legislative changes come from there. So this is something to consider. And this is also something we've, of course, expressed to the co-legislators, but I don't think that's contributing overall to easier compliance for businesses, which is also ultimately what's going to help consumers in this case as well. Maybe then moving to some of the more specific questions, which were also addressed by the consultation reply from the European Law Institute. And then first, the topic of the average consumer, which was already mentioned quite a lot today. And yeah, we have a bit of a different view on this. We believe that both the topic of the average consumer, the concept, and also the vulnerable consumers, they're already quite well established in case law, the Unfair Commercial Practice Directive, and also in the UCPD guidance, for instance. We think they provide a good degree of flexibility to consumers to protect consumers. But we do see that, for instance, if there's criteria on average of vulnerable consumers laid down by the courts, which have not yet been consolidated, that maybe they could be integrated to help legal certainty further. But we would not be in favor of an overhaul of the fundamental concept of the average consumer. What we think could also be helpful is if we do further research into which alternative methods may exist to increase the resilience of consumers online and offline. And also if we look at information requirements, because this is also something we hear quite often. So on the one hand, there's information overload, and on the other hand, there's information requirements. So where do we find the balance, and which information requirements do work and which don't? So some further research into this from our side would be very much welcomed. And we're also very happy to, as an association with our members, to think along of how consumers can best be informed about their obligations, both online or offline or omnichannel. on dark patterns, maybe specifically, I try to avoid this term because it's a bit of a vague term in which we're not completely sure what's included. So I rather stick to the term unfair practices. And we, of course, very much support the objective to protect consumers against unfair practices. But we do believe that this should be a channel neutral principle that's applicable regardless of the sales channel, so both in an online and in an offline environment. And we also do think that this is already quite broadly covered by existing legislation, such as the Unfair Commercial Practice Directive. And I do also want to point out that, of course, there are rogue traders active on the market, but as e-commerce Europe, we are convinced that the vast majority of businesses aims to be compliant with European legislation and does not intend to harm the consumer. We think that consumer trust is essential for running successfully a business and for customer loyalty. So we think that we could look further into which practices are particularly unclear to companies, so where the most of the mistakes occur, and if there's sufficient evidence that such practices are indeed unfair, and if they would fall in a gray area, these could be further specified. But we do believe that the overall principle raised rule should remain in place. Maybe some of the specific elements which have also been mentioned, for instance, cancellations. We've just seen the big discussion on the withdrawal button as well, and of course, we're not challenging the right of withdrawal, but we've been a bit hesitant about the button as such. And similar goes for the discussion on the cancellation button, where, of course, we're not challenging the fact that consumers should be able to cancel their subscriptions easily. We do see some risks, and this is also what we're hearing back from our members, in imposing a very specific technical solution. Because we talk about the digital sector, but we've also heard some examples, but the digital sector is very broad. And even within the digital commerce sector, it's very broad. There's very different types of companies, big and small, marketplaces, retailers, omni-channel. So it's very difficult for us to impose a very precise technical solution in that sense. I'm sorry, I'm in a room where there's automatic lighting going on and off, so I'm a bit in the dark at the moment. But yeah, these are just some initial observations from our side. We have a position paper where we address a bit more of the specific practices that are also in the public consultation. So I'm happy to go into those further also in the Q&A. Thank you.
Thank you. Thank you very much. Thank you very much also for this detailed presentation of a number of points, and I'm sure we will discuss a couple of them during the Q&A. At the same time, we realize that this consultation creates a lot of questions and further need for discussion, and that's fantastic. And therefore, I think it's the right moment now to get to the European Commission itself and to Egeline Brown. She's been working on EU consumer protection at DG Justice since 2016, including on initiatives such as the EU class action mechanism, the Commission's guidelines on consumer law, and a behavioral study on dark patterns. She is responsible for the coordination of work on the fitness check of EU consumer law. And she is, I wanted to say, also Estonian with a law degree from Maastricht University and the European University Institute in Florence. And I'm sure she has now all the answers to the questions and the remarks you have done, especially also on this aspect of at what pace things go, because some changes occur in different sectors while this fitness check is still ongoing. But I do not want to preempt what you want to say. You have the word, Egeline Brown. Thank you.
Thank you so much, and it's really an honor and a privilege to be here at the European Law Institute event dedicated to the fitness check, because if I'm imagining discussions about evaluating the state of play of these key horizontal consumer law instruments, I can hardly imagine a better setting and the people to discuss it with. So very glad to be here, and I took a lot of notes also from the previous speakers. Maybe I would just like to start with giving you the more general line, let's say, that the Commission currently has. So, of course, you know why we started the fitness check. There are good reasons to conduct this evaluation, but also good reasons to do this at this specific time. So instead of now rushing to add yet some other proposal to the very growing list of digital acts that have been adopted recently, like the Digital Services Act, the Digital Markets Act, or those which are still under negotiation, like the AI Act or Data Act, or even, as we heard today, you have to stay vigilant because digital laws can pop up even in places like the Consumer Credit Directive, Distance Marketing of Financial Services Directive, even the Green Empowerment of Consumers Directive. So in this context, this ever-changing context, the decision was made, and I think rightly so, to take the time until the end of this Commission's mandate to see whether overall this framework is sufficient or not, and to also give the necessary time to all these other acts to sort of settle, enter into force, and perhaps even to see some first indications of how they are being applied. And let's not forget that the most recent amendments to the UCPD, CRD, UCTD only entered into application last year with the Omnibus or Modernization Directive. So in a sense, the fitness check is trying to develop an understanding of where we are at now. And technically speaking, it does look at past performance, at how these three directives specifically have performed in the digital age. And time-wise, we are looking also specifically at how things have developed since the last fitness check we had, which for those of you who are following this field for a while, you know that it was only in 2017 that we concluded the last fitness check. Although that fitness check was quite a different kind of endeavor. First of all, it covered a lot more directives. It was covering all practices, so online, offline. And that eventually led to the New Deal for Consumers package, which had some very revolutionary aspects like collective redress, long awaited, but also some, I would say, more targeted fine-tuning in the Omnibus Modernization Directive. So we have to bear in mind that not too long ago, the Commission concluded that the rules, the very same rules, were overall fit for purpose, but that they would nevertheless benefit from some targeted strengthening and better enforcement, of course. So in that context, well, my personal view is that it will indeed be challenging to claim that there are fundamental problems with these consumer law instruments. But of course, the reality is that problematic practices continue. Consumers are not enforcing their rights. And these practices are going to continue being problematic. They're going to become more intelligent as technology develops. So even though many concerns, I'm sure, can be addressed by better enforcement if the authorities had the resources to go after most traders, or by guidelines like the Commission did with its non-binding guidelines, or by dialogue with market participants, which we are constantly doing, whether it's on the cookie consent topic. For instance, tomorrow there will be a discussion with stakeholders on how to ensure maybe some voluntary approaches to improve the situation of cookie fatigue, but also many other examples. So I think in light of all of this, there still can be a case made, and quite a convincing case, that in addition to better enforcement, guidelines, dialogue, there may be also a benefit in being clearer in the law about what exactly is being required, and of course to do so at the European level. So in a nutshell, even though the fitness check looks at past performance, it certainly is understandable that everybody's interested in the future, about the next steps. And so will there be a legislative follow-up? And the short answer is that it's too early to judge. So I cannot prejudge the outcome of the Commission's evaluation. So you'll have to stay tuned, let's say 1 year from now. But we will certainly be giving an answer to that. So that is the expectation. And in case, and that's a big if, there is a political decision that something more should be done, then that would only happen under the next Commission mandate. So we're talking about 2025 at the earliest. So this concludes my sort of overall broader logic of what we are trying to achieve here, and giving you a better sense of why now, why like this, why these topics. Going into more practical matters, the Commission's activities for the fitness check involve evidence gathering through different means. So first and foremost, we have concluded the so-called call for evidence and a public consultation, which gathered quite some interest. from all of our key stakeholders, but also from a lot of EU citizens, which was quite surprising. Normally, the consumer law topics, even though they are so close to the citizens, they're not exactly the hot topic that people are rushing to the Commission's website to fill surveys. But that was a positive surprise. And indeed, one trend I have observed is that while consumer organizations, NGOs, academics, and certain member states are clearly pointing at some problem areas and questioning whether the law is sufficient, on the other side, industry representatives are rather hesitant about the need for more legislative action in particular, and they rather recommend to focus on the better enforcement of existing rules. So that's for sure going to be a common theme as the fitness check goes on. But nearly 42% of respondents to the public consultation did consider there to be some legal gaps, or at least some or legal uncertainties in the current framework. So moreover, they also considered, or a large percentage were questioning whether traders comply well with consumer law in the digital environment, and also that people were questioning whether EU consumer law is actually coherent with a lot of this other EU legislation in the digital area. We saw some very colorful examples of that in the ELI paper and the presentation earlier about the DSA dark patterns provision, which indeed will require quite some interpretation, that's for sure. And there were also, let's say, mixed results so far about whether EU consumer laws as such, together with all those other new instruments, provide now the sufficient amount of protection. So let's see. I mean, this is, I guess the answer would depend on what we are talking about concretely. If we look at the overall state of play, certainly European consumers are the most protected. But then if we go down to the details of, let's say, influencer marketing or loot boxes in video games, many question marks arise because the laws are pretty much silent on those points. We also saw a lot of reports about problematic practices from consumers. So things that were occurring most frequently were this obligation to provide payment details for free trials, which as such is not an illegal practice, but may nevertheless be viewed as problematic. Also, 88% encountered some dark patterns in the last year. 74% saw a lack of disclosure by social media influencers. There were also difficulties with canceling contracts and automatic renewals without reminders. And maybe what's the saddest of all, but certainly I'm not surprised, is that the majority of consumers, so approximately 88%, did not take any action at all to solve the problems they encountered. So this is a bit of a distinction between the online and offline world, even though in general consumers are not really enforcing their rights. I mean, simply the costs, the knowledge, the time involved may not be worth it always. But in particular, when it comes to some of these digital practices, I mean, some of the dark patterns that we see on a daily basis, I mean, are you really going to go take the time to fill in a complaint form whenever you're exposed to such practices? I mean, it's doubtful. So it's definitely clear that here maybe the onus should not be on the individual consumer to solve these more systematic issues. And indeed, just to be a bit more brief now, when looking at the responses to some of the suggestions that we flagged, which the ELI paper was focused on, so these concrete, more future-looking ideas, we received majority support for all of them. So it seems that they are not really controversial. Even ideas like shifting the burden of proof were met with a lot of support. Although, of course, it is a bold idea, which will have some implications, and I can already see industry organizations in particular doubting whether that's proportionate, but it's certainly something that we will continue considering. And in addition to all these consultation surveys, and I'm very much looking forward to also the BEUC survey, which seemed to correspond quite a bit to some of the findings that we had. In addition to all of this, we also have a supporting study that's ongoing by an external contractor. So this study will examine all of the technical evaluation questions that we have with this fitness check. And it also, by the way, prepares the ground for the application report on the Omnibus or Modernization Directive. So rest assured, the observations concerning the functioning of the Omnibus directive will also be fully taken into account in the fitness check context. So these two are parallel processes and they will feed into each other. So if we see something went wrong with the Omnibus rules, there will be an occasion in the context of the fitness check, if we're talking about digital practices, to reevaluate those issues. And in that study of the external contractor, there will also be additional surveys and actually a representative survey of consumers, a survey of businesses via phone. So we are also going to try and capture some views from SMEs, and also a targeted stakeholder survey where there will be another occasion for our stakeholders, including all of you here, to react and provide more detailed insights, for instance, about issues like what are the compliance costs that businesses face with the current rules, or when they are trying to understand and comply with the current rules. And also the study will involve sweeps, or a type of mystery shopping exercise to check what the market practices currently are as concerns specific topics. To keep the confidentiality of that work, I won't be going into detail about the topics or websites that will be examined, but certainly that will be a very useful source of empirical data about compliance. And of course, we are trying to synthesize all the information, all the existing research on the very many topics under evaluation. So it's certainly not an easy task. So we're looking at also the past actions by enforcement authorities, by the CPC network. We look at reports, for instance, by the European Parliament. Some of you have contributed to those studies in the past. Like more recently, we saw a study in the IMCO committee on influencer marketing, on personalized pricing. So we are also reading all of that carefully. And so maybe last but not least, before we get to the Q&A, I also feel a duty to sort of highlight one element of the fitness check, which we are often forgetting about, because people, especially lawyers, we are always interested in what does the law say and how can we improve it. But one mandatory element of every commission evaluation is also to check whether there is any scope for burden reduction, cost savings, and simplification. So we are, myself in particular, I'm of course very sensitive to any possible ideas of reducing the level of consumer protection, but we are speaking here about looking if there are any possible adaptations that could be proportionate and justified. Normally this kind of category includes also issues like reporting obligations, the cumulative reporting obligations that, for instance, companies will have now as a result of the DSA, or as a result of GDPR, risk assessments. So all of that together. So far, we don't have such an issue in consumer law because we barely have any such reporting requirements. But it's this type of thinking that also we have to reflect in the fitness check. So in case you have any ideas on what could be some easy pickings for further simplification, I'm also very interested in hearing any thoughts. So I'll stop there, and also very much looking forward to the questions and answers.
Thank you very much. Thank you very much for this very specific also presentation. And I was just thinking, listening to you, it will be a challenge to keep up with this 1-year deadline that you mentioned, because if you want to read everything about information, withdrawal, digitalization, and so on, and look at all the surveys, probably you need an AI to do that, and that will be even more complicated. But fun apart, I think it will be fun and interesting, and we certainly look forward, and we will look into that. What I want to suggest for the Q&A and the about 20-25 minutes we have at our disposal is maybe to answer first the questions that we have from the participant, and then come back to the various panelists and the reporters to have maybe reactions also to what Eglyn Brown said in particular. The first question that was posed is an interesting one, because in the ELI response to the EC public consultation, well, the ELI underlined the right to have a human interlocutor. And therefore, the question is whether the reporters think that the human interlocutor would be less pervasive as far as consumer decisional autonomy is concerned, could be less nudged, if I can use that word, given the author of the question, and also whether that would be safer. Or is it just a matter of, you know, analogic approach and say, well, maybe digitalization is not everything. Some people cannot have access to digitalization. Others do not want to have access to digitalization. And therefore, should we not give these people also an opportunity? I don't know whether, Marie-Jewel, you want to answer that question, because you addressed the point.
Oh, I think it was Karen, actually. Karen, you addressed the point. Can you take it? Yeah.
Yeah, indeed,
Yes.
sorry.
Yeah, thank you for the question. And indeed, we really only considered the issue that human beings are easier, or we presume they are easier to communicate with. This is so because the Commission's questionnaire only addressed the question of consumer complaints. The question reads, where automations/bots are used to deal with consumer complaints and other inquiries, consumers should have the possibility of contacting a human interlocutor upon request. So therefore, we didn't address the issue of decisional autonomy at all. And we proceeded from the, I think, the understanding that although automation and bots are getting better and better, I think most of the consumers have had the experience that at some point they fail or they are not able to answer. And of course, as Pascal already mentioned it, many consumers are not yet digital natives. They don't lack the skills or the wish to be digital. And I think we should take our grandmothers in account, that we should allow them to be non-digital for the time being. Thank you.
Thank you very much, Karine. Of course, it's not only about grandmothers or grandfathers, right? You might have a younger generation that just want to be away from digitalization, and that should also be an autonomy of will that should be respected.
Absolutely.
Kind of fundamental right not to be digital, if I may say so. Kasper Drazewski, you wanted to react as well.
Yes, thank you very much. I couldn't help noticing that, in a way, this question, with this question, the Commission preempted the explosion of popularity of GPT-based chatbots. And our concern as BEUC is that even though these chatbots can be seen as much better at delivering what tasks they're put to performing, but they can also be quite misleading in the sense that they are not they're not necessarily better substantively, but they are extremely good at sounding plausible. And this is something that OpenAI says quite openly in their terms and conditions, that the veracity of the responses need to be assessed depending on a particular context, and that every user should assess individually whether what they're getting is true. So and as I only saw this morning on Twitter, that in internal Google communications, there were some serious concerns about the susceptibility of the large language models to acting like as pathological liars, quote unquote. So in that respect, I believe that as we're looking at the deployment of large language models as chatbots for companies, we've seen Expedia being one of the first. There are big concerns over consumers being misled, not because of the language model being more accurate, but because it sounds more plausible as it remains inaccurate. Thank you.
Thank you very much. And what you've just said is interesting because it can lead to the second question we have by panel by the attendees, which is linked to the information and the transparency and the substantive transparency. And the question is whether by strengthening the transparency and also maybe adapting the information, we could not empower a bit more consumers and for instance use what has been developed for the unfair commercial terms directive also in other sectors. Now Peter what you said, information is not everything, and you reminded us very rightfully about this. I was just thinking maybe you want to react first, and of course I will also ask Egelin Brown afterwards, but maybe Peter, you want to say something on that. You're still muted. But if you don't want to react, that's fine, right? I don't want to. You're still muted.
I'm happy to leave it to
okay.
For the time being.
Okay, I like information, so that's why I picked up also this question, because I think it's very central. Egelin Brown, please.
Yes, no, thank you for the question. Indeed, it's like one of these age-old questions in consumer law. In addition to we need better enforcement, the other point is about, okay, what to do with information overload. As a fan of consumer law myself, I don't think myself or anybody in the Commission has any illusions at this point that information is a panacea and that we can solve even half of these questions by giving consumers more or better information. So I think we have sort of moved past that point. But when it comes to information, I mean, it's still nevertheless something that consumers need to have. It is an important resource, not only for proving then if in case an infringement took place, or simply for comparing different services, for consumer choice more generally. So it certainly has its place, but then my question is, I would not be discussing it at this very kind of high level, but rather I would look at case by case or topic per topic. So is information an adequate response for the question of dark patterns? Empirical studies have shown it is not. The Commission conducted a behavioral study last year, and there we conducted different experiments, different versions of popular dark patterns, and we tried to apply a remedy that you can actually test in a, let's say, scientific way in a lab. And that remedy was one of information, or better transparency, and also a cool down moment. So really artificially creating for the consumer a moment of rest where they are shown exactly what they are going to be getting into, the full cost and everything, and still they were affected by the dark pattern. So indeed, overall my question is, or my answer is rather, that it depends, and information is not a panacea. And here, although it's true that the Commission's questionnaire did include a lot of references to new information duties, it's not necessarily with the intention of making sure that consumers are going to be overloaded or given more information. So it's, in the end, it will have to be a balanced approach, of course.
Thank you very much for this very acute answer. And you mentioned balanced approach. This is also a balance between, cost and efficiency. And Mikey Jansen, you mentioned, of course, the burden on also traders and producers to adapt to the information load and to web design that would, protect probably better and inform better. I don't know whether you want to react to that aspect and maybe elaborate a little bit on that.
Yeah, I can. Yeah, I mean, I think from the side of business, there's also a balance to be found. So on the one hand, of course, we have to be compliant with all these information obligations. And I get that it's not the holy grail of solutions, but yet they keep being added in various pieces of legislation. So it is something that business need to deal with. So maybe we could think about if there's some way of we can prioritize these types of information obligations to present to consumers with the most relevant. So some sort of hierarchy we can address there. But at the same time, for instance, addressing the questions of summaries of terms and conditions, I think, of course, for business it would be easier to present a summary of terms and conditions, but it would also open up a way where there's risks of that you can be told that you're omitting certain information to the consumer, or you're not presenting it clearly enough. So we need to balance also these two sides, where on the one hand, business needs to be compliant, need to present all the information. On the other hand, we see that consumers may not take in all the information. So this is something to consider more broadly, I think, than only here. And maybe something to mention that I think was also addressed in the ELI response, for instance, with regards to cookie banners, which is quite a timely topic, because actually tomorrow there's a roundtable for the Commission where they're discussing the initiative of a potential cookie pledge. So there's work into this. And it was, for instance, the idea mentioned of standard, I think it was also mentioned earlier by Mr. Roth. And I think, of course, I mean, we're not such a fan of binding standards, but at the same time, we do really see the benefit of standards, especially for smaller companies. If there would be some sort of standard or approach that they could apply more broadly, that would save a lot, because there's also a bit of a knowledge gap there. So we would definitely be interested in exploring further the idea of standards that could be easily applied also by businesses. Makes it easier to check compliance and also easier for business to implement certain changes. So this is something we're very open to exploring further.
Thank you very much indeed. I think this aspect of standardization might be very useful. Of course, we've heard Eglyn Brown saying it depends. It depends also on the type of businesses, on the type of websites, and the question we have from one of the participants saying, but how to design it really to have something that is compliant is not easy. We will probably not be able now to explain, how to do it, but that implies also a number of aspects. I do not see further questions right now in the process, so maybe I can just come up with one question on which was about the where it is, here it is, yeah, about the issue of no, it's not here, sorry. Yeah, here about the free trial. And well, we all use that and that opportunity, or some of you might not, because you know what are the risks. But the issue is always at some point you get the information, you can, it will be automatically renewed. I was just wondering whether we should not induce, or at least make consumers more aware that they could take the free trial and at the same time, a couple of minutes later, already say that they do not want the renewal. I had a colleague who would do that all the time, not online, but in practice, just to be sure that she will not forget about the automatic renewal. And this is maybe also about consumer education on using what is at hand, because maybe the way it is presented often, it gives the impression you are not allowed to say now that you don't want the renewal. You have to wait until you get the information. Is there not here also something to be done? I don't know who wants to react to that. Maybe no one. I did not see. Ah, yeah, Casper, if you want to, and then Karin.
Thank you. Just very briefly, there was one question in the Q&A list about fairness by design, and
yes.
I think this is exactly, we're touching upon this subject also here, because if you think of how many biases, and we already know that the average consumer is biased, how many biases people employ even at the level of using subscriptions, using trials, using free trials, and how much room there is for fairness by design, understood as going one step further, not offering neutrality, offering design choices which counteract and seek to prevent known decision-making biases. And the Commission's question about reminders on inactive subscriptions, that was exactly it. And here we're talking about free trial becoming a paid subscription, and it may already be a result of the ongoing fitness check. But I've seen personally anecdotal evidence. I've seen a considerable improvement in practices of online companies that how they handle free trials. I've been seeing emails in my mailbox saying your free trial will expire in 2 days and then your credit card will be charged on this and this date. This is brilliant. This is exactly what we're talking about, and this is a polar opposite of what you said, Pascal, about you not being able to say no immediately. Let's wait it out. Let's see if you forget. So this is exactly what we're looking at. And one more thing, we mentioned efficiency, and this is something that ties into. This is also, companies have massive, big tech companies have incredible resources on based on behavioral observation, based on behavioral data. When we ask where when we want to ask the question, where is what design choices should be implemented in order to prevent known decision-making biases, I believe it's very fair to ask companies which have been dealing with this. It's the same way as the reversal of the burden of proof, in the sense that in the interest of efficiency, in this triangle between the consumer, the big tech company, and the regulator, the actor which will produce the information at the cheapest cost will be the economic actor, will not be the other two parties. And just so it's part of the same story. It's reaching where the information is.
Yeah, thank you very much. Karin, you wanted to react. You have also the floor.
Yeah, concerning the reminders on free trials, I believe that if we introduce the requirement of getting an express consent from the consumer before it converts into paid version, then we don't need an additional reminder at that point. So that already reminds me that I have something like that. What I also was thinking about, listening to Kasper, who said that we already see good practices on the market. Indeed, I had one myself concerning an insurance product, and that led me thinking that we should have actually the same provision also for financial products or distance marketed financial products. And I don't think we'd have that in the proposal for distance marketing of financial goods and services. Thanks.
Thank you very much. I see in the Q&A also a question regarding the free choice of technical implementation, and saying, okay, but is there not a balance to be made also between designing and free choice, and how could the rule of proportionality be activated here? And I think that the idea expressed also in the presentation by Peter wrote on the standardization goes into that balancing. Or would you say that standardization would be a good step forward as well? Because I did not give you the opportunity to react on that when Mikey Jensen spoke about it. Peter, do you want to say something on that?
Yeah, this time I noticed. Well, in my mind, there are say elements of your presentation on the internet, web design, and so on, where there is a point in being creative to distinguish yourself from other presentations, etc., be especially sustainable or whatever. And there are things where you simply have to perform a legal task. And where you simply have to perform a legal task, I can't see why everybody should be allowed to choose the way in which they should do that, and how colorful they design it, and which then creates the risk of dark patterns of all kinds. And the cookie banners are a beautiful example. I'm sure you know that initiative by Con Policy, together with all sorts of stakeholders, where they have created what I find a very reasonable way of handling this. And if simply everybody would use that, consumers would get used to it, would know what to do, and you don't start like searching all over again. And is it top right or bottom left or in the middle or hidden or green or gray, or have they changed green and red twice during the process and so on, which costs me personally a lot of time because I always do that. And sometimes I close websites when I get too annoyed about them. And there are more examples of that. So where you simply have to perform legal tasks, I think, in the balance between freedom of expression of traders and consumer protection should tip to the consumer side of things. And as you perfectly rightly said, I think this also has, I mean, that this may cost business to web designers, but I'm sure it would be much easier for many businesses that are not interested, not even think about dark patterns, but end up with them because they have been designed for them by someone else. And in the end, they risk being challenged by authorities, being pursued by their competitors, and so on. So I think a proper review of what could be standardized easily. I mean, think of chemicals. There is for a flammable chemical, there is one design, and that's fixed by the law. And you can't, and not everybody's allowed to fix their or to make their own designs. It just makes sense to me.
Yeah.
Thank you.
Thank you very much. Eglin Brown, please.
Yes, no, I just wanted to add a bit also to this question. Well, first of all, I think Professor Roth is spot on in terms of where that balance should be, that indeed, when we're talking about legal obligations, concrete rights to consumers, I don't think it should be a free-for-all in terms of, web or app design. But indeed, I do see I have mixed feelings about this. Let's put it like that. In a way, I'm very much in favor of being more precise about what is expected for all parties involved. On the other hand, if we're going to have EU laws that literally dictate what web design should look like, what should be the color or size of the buttons, and this is more of a trend now. You see this in past proposals, even in the Omnibus Directive. Things like on what page, when you are seeing search results, where exactly should certain information be shown to you. That is very prescriptive, and I sympathize with web developers and the compliance teams of companies who will have to explain to their teams that there are so many nuances. You have to keep a checklist of where everything is. So indeed, it's I see both sides here, and probably some balance needs to be achieved. I will say, however, thinking about things like the rule of proportionality, it's all very nice to reflect about this in academic papers, but in reality, based on what I've seen in Brussels and some of these other past legislative negotiations, once the proposal from the Commission side is out, and here indeed we are asked to develop evidence-based reflections, proportionate based on better regulation rules. But once it's out there, once you enter into negotiations, it is not a scientific process. It becomes a negotiated compromise, and things could come in about buttons, about functionalities, using words which could be outdated in 5 years, using words which are not technology neutral. For virtual worlds, for instance, they may be, still thinking about websites like in the 90s. You see your desktop, and that's how we think about things. So it is a challenge, and I'm afraid there is not going to be any perfect solution simply because the way laws are being made. But we will, of course, try our best, and we rely on you to flag to us also sometimes when things are going a bit off track.
Thank you very much. I might give the floor to Marie-Jo Sorensen to give a last statement in the name of the reporters, and then I will just conclude.
Well, thank you. I don't have that much. It has been an extremely interesting work, and I think we agree, Eglin, and also Maike, that basically we are on track, but there are certain things that we could improve, and then I think that would be our final words.
Thank you very much. Thank you very much on my side to all of you. First of all, to the 3 reporters for the work you've done for this ELI response, but also to all the panelists to take the time on your lunch break, if I may say so, to come and join us in reflecting on the various strategies, possibilities, and in particular also my thanks to Egeline Brown to coming and explain us what are the next steps also and the difficulties linked to these next steps. Thank you also to everyone who attended this webinar. As you know, this webinar will also be recorded and available later on, so those who could not join will also see us. But for the time being, I just want to say thank you and look forward to further meetings online, further webinar. Thank you and have a great day. Thank you. Bye-bye.